I actually do have livestock. I farm, and I always tell people that I farm in God's country. And you all are here. You're all in Scott County. This is great that we're able to host you in the county I grew up in. And I swear, I think I grew up in the extension office right here. My parents thought it was a lot cheaper than a babysitter. So the fence laws for Kentucky are in the very back of your books. There's a tab, and I thought we would just go through them in order. And then if we have time, I can show you online at the LRC where to actually navigate and go find these things, particularly once you understand the fence laws. Typically you need to have a discussion with your neighbor and make them aware of the fence laws. So the fence laws in Kentucky, a lot of people, even this morning, I got a law that was Kentucky a fence in or fence out state. It was somebody from Texas that moved here, and I thought, gosh, before you even talk about fence, Mr. Texan, you've got to understand the background that we have. We are not the open range. We're not the Wild West. In Kentucky, we're not really a fence in or a fence out state. You are required to have a boundary line fence state. And that makes us or deems us to be an enclosure state by that very fact. So like all good attorneys, let's start at the definitions page, because the definitions, once you understand how messed up the definitions are, the rest of it will kind of make sense. It's kind of that adage of, you don't have to be crazy to work here, we'll train you. That is the fence law here. So the fence law in Kentucky, you are required to have a lawful fence. Well, let's read this thing, and then let's read when it was created. Down at the very bottom of your page, the General Assembly lists the years in which laws were enacted. So this law was created in 1942. In 1942, what else was America doing besides drafting really cutting-edge fence laws? We were right in the middle of the Second World War. And the General Assembly had to get together and create some fence laws. Some of this stuff was new at the time, and I have had a chance to go back and read the history of fence laws, Chris, and that'll blow your hair back. I could hardly sleep at night doing that. But some of this stuff stretches back to medieval times and enclosure of cattle in England. A lot of Kentucky's common law stretches all the way back to England. We were part of Virginia. Virginia was part of the English colonial process. So a lot of these laws were written contemplating cattle and escapes from England, and that might make a lot more of this make sense when we talk about the height of the cattle. So up in 1A, a lawful fence in Kentucky means a strong and sound fence 4 feet high. Let that just marinate for a second. 4 feet tall is this tall. So think about if you've ever been to Garrigus on the UK campus. There used to be a couple pictures here in the extension office. They might be down in the basement. But have you ever looked at cattle, the Angus cattle from 50, 60 years ago? A 4-foot fence would have probably held them in, because we didn't breed cattle for size until about the Second World War. And then they got to modern heights at that time. So it's got to be 4 feet high. It's the second part of this that's mind-blowing. So close that cattle cannot creep through it. How many people in this room have ever witnessed cattle creep through a fence? You have? Were you cussing them when that happened?
It wasn't my cattle.
Oh, okay, it wasn't your cattle. Well, that's good. I've never seen a cow creep through a fence. I have seen cattle explode through a fence. I have seen them storm fences like it was D-Day and they were getting on the beachhead. Cattle typically violently escape the enclosure that they're in. But here, cattle are not supposed to be able to creep through the fence, meaning they've got to be tight enough, low enough on the ground that they're not being able to nudge through and pop them up. Here in the law, cattle is defined as any livestock. That's another bit of wisdom in Kentucky. So when you read the law here, cattle is deemed to mean all livestock. So if you are enclosing horses, that also has to meet the definition. Sheep, goats, pigs, if you're free-ranging pigs, or any other manner of animal that you want to have on your farm, you need to build the fence sufficient enough that that animal cannot creep through here. Now, sometimes we have these where people bring their kids to them, or there's an evening program where somebody, like my parents when I was little, it's, come on, Clint, you're going to the extension office for yet another meeting. Maybe they'll have some sandwiches too, so you don't starve. Usually I ask a kid what they think a good fence is. So if you're a judge, and if you're from Scott County, there are judicial elections that happened last year. Do you think any of those judges, in the event of a lawsuit, is going to come out with a tape measure and start tape measuring your fence and checking it out? Likely not, right? That might get stuff on their robes. They're busy people. So what do you think, if you were a judge, you were going to deem a fence to be a good fence, a good and lawful fence? What would you call it? This isn't a trick question, I promise. Do what?
Solid, something that will keep them in.
A fence that'll keep them in is a good fence. And you're absolutely right. So this is one thing where common law or judge-made law has been overridden by the court system. Here, the courts have deemed your fence is good enough if it keeps the cattle in. So I think we can all agree on that, right? How many people drove here today? You got in your car from your house and you drove to the extension office and you passed by some pastures and thought, the only reason those cattle are in there is because they want to be. Has anybody passed fence like that? Here's an even better one. You're going to a place after lunch where the cattle just want to be there. It's great. Jeremy has seen my fences. I've not let him look at anything else because I don't want to end up as an example of what not to do on there. I have used tires for insulators before and whatever else was handy. I have used the touching the fence to see if it's on method. That's one that I like to entertain guests with. Here, if the fence is good enough to keep the cattle in, it's good enough. That has a lot to do with the temperament of the stock that you're running and the interactions that you all have. Keeping new batches of steers in is a very different concept than your 20-year-old mare that likes hanging out and being comfortable. You have the responsibility to keep your cattle in. As we flip the page, I'll show you where. In 030, and we're going to skip one and we're going to come back to the agreement for division of fences, but in 030, this is one of two places where the General Assembly reminds us that simply being a landowner creates in you a responsibility to maintain fence. So in 030, it says a couple of different things. It says that each party, meaning neighbors here, shall keep a lawful fence in good shape. And if one party, that is you or your neighbor, fail to maintain that fence in good shape, then you are liable to somebody in the event of a lawsuit, either liable to the neighbor or liable to a third party if the cattle escape just simply the line in between you and wander out typically to the road or onto another neighbor's place and causes damage. In sub 3 of that, it talks about placing liens on the livestock in the event of an accident, an escape where damages are created. Think about that intuitively. I'm going to guess that everyone in this room has livestock, and you're not just recreationally coming to a fence school. You can, they're fun, but the lien is placed on livestock. The responsibility for maintaining their half of the fence is on a neighbor. So if a neighbor does not have livestock and the cattle escape, the lien is still coming back on your cattle because you're typically going to be sharing some damages at that point, and we'll talk about that in a minute. But everybody can see here, this is instance number 1 where the General Assembly reminds everybody that by having livestock or by being adjoining landowners, you have an obligation to maintain your fence. Let's slide up for a second in 020. I don't mean to gloss over this one, and with Chris, we've been doing the fence school for a number of years, and I've probably talked to 30 different counties about agreements for division line fence. 020 is something that doesn't happen very often in other counties, but this is a very real thing in Scott County, and I want you all to check it. In 020, it is possible that you and your neighbor could have a pre-existing agreement for who maintains the fence. And I don't want to ever gloss over that thing, because it is possible that you and your neighbor, through prior agreements from the mutual landowners that were predecessors in title, you all could have had, you could be signing up for something where a fence line obligation already exists that is outside the norm. You and your neighbor can always get together and think of creative ways to split the maintenance of the fence, or different ways to either fully share or fully exclude the maintenance of the fence. And if you do that, you can write it up and you can file it in the Les Pettis book if you're here in Scott County. And an agreement that would override the rest of the laws can and do exist. And I've written a few of them in Scott County, so beware. Particularly if you're next to a subdivision, or if you're a subdivision owner. I may have written one that put all the fence obligation on the subdivision owner, not the farmer, because I've clearly picked a side there. Yes, sir?
Which end of the farm is your fence?
Okay.
Neighbors, I've been told that if you're facing, your right side is your end, and when he faces his, the right side.
Yes, sir. And for the benefit of the people in Princeton on Thursday, his question was, who maintains what part of the fence, or whose fence is whose? So in your book, on the very next page, is KRS 256-042. So in 042, we're going to go through this statute in its entirety, but skip all the way down to 6. So KRS 040 or 256-042. Sub 6 in my book, it's right across from where we were just reading, towards the bottom. This thing says, in all instances, when you and I are neighbors, and I'll just pick you. What's your name, sir?
My name?
Yeah.
Lloyd McKinney.
Mr. McKinney and I are neighbors. So Mr. McKinney and I share, just because I like easy math, we share a 1,000-foot fence line. Meaning that our boundary fence and our deeds, and hopefully both of us have plats that will show there is 1,000 feet of common boundary between us. So first of all, boundary line fence really does mean boundary. You have got to place a boundary line fence on the boundary, and that's something I'll warn you about here again in a second. But he and I, if we meet at the 500-foot mark, number one, if you ever go and find the 50% mark with somebody, what are you going to do? Mark it. Mark it every single time you do that, because you've probably gone out there and marked it for a reason, right? What are we going to use to mark it with? I'll tell you what you should do, and I'll tell you what I do. I will put a T-post in the ground. Then I'll forget about the T-post. Then I will run over it with a tractor and violently find, or remember, usually with a front end tire, exactly where I placed that T-post at some point prior. Don't do that. Put a mark there and make the mark very visible. That way everybody can go see it. And then Mr. McKinney and I are going to stand. You're going to be on your property or on your farm, and I'm going to be on mine, and we're meeting at the 500-foot mark. And as we are looking at each other, we are both responsible for the fence to our right. So my right is your left. Right? So this part, 50%. This part's mine to maintain. This part, your right, is yours to maintain. Does that make sense to everybody?
That's the way we used to divide it on the farm if we owned. With our neighbors, we do work.
Yeah, and you knew what was what and whose was whose. And that's really important. And that is a major misconception in the fence law, is that it's not half. You are responsible for technically your half of the fence, which is your 50% to maintain. It is not 50% of the total cost of the fence. And you all can see how that's going to be a radically different thing, right? Where we're going this afternoon, part of it is really easy to put in fence posts because there's actual topsoil. That farm 150 years ago was divided with an old rock fence, if you all want to go out there and look at it. And on the other side of the rock fence, I don't know that you can go down 3 or 4 inches and not hit rock at that point on the other side of the fence. And the people that did that a long time ago picked a pretty good place to divide that because one part's different than the other. It does not make a bit of difference in the fence law if your neighbor's is 4 foot of good topsoil, easy to build, perfectly straight, no trees in the way, no brushes, and your side is all rock, 3 mountains, 4 water gaps, Hades over there on the side of it. It simply doesn't matter. The law arbitrarily picked a 50% mark, and you just naturally get what the law deemed you to maintain. Does that make sense to everybody? Chris?
So I was just thinking about your example of the rock wall. So rock fence is extremely expensive to repair and maintain.
Yes.
So if it's there, is your neighbor obligated to keep that fence, or could he tear it down and put in a woven wire fence?
That is a great question. So when we go out there this afternoon, we'll go look at the rock fence that exists. I'm in love with rock fence. I am not in love with the cost that I was quoted yesterday on fixing it. That is $100 a foot. Have you all heard that? Wait do you all go price a fence post this afternoon? Do you all know what a 6-inch fence post costs now? Yeah, they're very expensive as well. But are you required to maintain the exact same type of fence? And there are wonderful lawsuits about this, and they pepper the board with how a judge decided it, because the fence typically has value in and of itself. So if the fence is genuinely placed right on the line, the argument is they could remove it, their 50% of it, but there's value to that. And usually once both sides hash that out, both sides can come to an agreement of who's getting the woven wire typically tucked in on their side of the fence. But there is not a hard and fast rule in Kentucky on the stone fence. And stone fence, I mean, it is beautiful, but it is really ineffective at keeping cattle in one side or the other. And you'll see my efforts where we're going, or maybe more accurately, my lack thereof. That is the next part to tackle. That farm, I have, I think, 2.5 miles of borderline fence with the neighbor, and all of the rock fence is on me. So I don't know what I'm going to do, but I own an excavator and a dump truck. I will try to preserve the fence, but at $100 a foot, it may be untenable to try to keep that. Yes, sir.
Have you encountered a situation where the two parties should agree, hey, 50% of it's mine, whatever repairs are, I'll split it with you?
Okay, for the benefit of the people in Princeton, he said, have you ever encountered a situation where somebody has called you and said, my neighbor and I have agreed to maintain the fence 50-50? No. I've been practicing law for 17 years. People only call me with problems. Nobody has ever called me up and said, Clint, I'm getting along great with my neighbor. I hope you're having a great day. No, that has never happened to me ever. But that's an ideal situation. And when we talk about maintenance of the fence in a few minutes and how to go about that conversation with a neighbor, the situation you're describing is ideal. I think if both sides recognize that they have an obligation, typically that's easier when both sides are engaged in agriculture. That's a perfect situation. You need to buy lottery tickets. If you've done that twice in your life, you're ahead of the game. I think society is becoming increasingly litigious, and there are big fights. Particularly, do we have very many people that are Scott Countyans in here? No, everybody? Just me? Wow. All right. In the bluegrass region here then, it's increasingly popular to own a farm that is next to a subdivision or 5-acre lots or something like that. And that's a hard conversation to have sometimes with somebody who went by, found the dream home out in the country. They're watching YouTube videos on farmsteading. They're wanting to make all of their stuff. And when you approach them about their fence line obligations, that might not have been something that they figured on in purchasing the property, the cost of that maintenance and the obligation that they have. So I think having those initial conversations in a non-threatening, neutral manner might lead to better fruit than showing up and plopping the fence law down and say, let's go build some fence. But the Central Kentucky bluegrass region is rapidly changing with large farms being busted up into smaller ones. Scott County's particularly bad about that. So it's not uncommon to have a farm and then have multiple neighbors. One tract that I farm over on Lemons Mill Road, I have better than 300 neighbors that I kind of farm a peninsula in behind some subdivisions. And technically under the fence law, I would be responsible for 50% of 300 100-foot wide lots. So think about that as a landowner. Sometimes the phrase is it's easier to plow around the stump. Sometimes it's easier as a cattle producer to go on and pay for all of the fence. But let's talk about the rest of our obligations under the fence law. On the next page, because we're going to come back to 042, because I want to talk about the process for when things get a little sideways. In 256.080, this is the one that should cause you some panic or keep you up. This is the paragraph in the law that should frighten you enough to go build fence. And it goes to state that the livestock need to be contained, and if they escape the property, you pay damages. So if a cow gets out, it finds the road and it causes an accident, and let's say you got lucky and it struck a vehicle or a vehicle hit it because it was out in the road and caused $10,000 worth of damages. Well, you would, if the cow escaped from your part of the fence to maintain, you would be writing a $10,000 check to whoever you caused damages to in order to, the legal term is, make them whole, right? You fix it like it was because you were liable for that damage. In the middle of that paragraph, it goes on to state, for every subsequent trespass by the livestock of the same owner, double damages, meaning the second time, now granted, it's probably not the same cow, right? The cow, that was probably its last cow event on this earth, the first time it was struck. But let's just say, for giggle's sake, that the same girl got out. The second time that there's an escape, even though it cost $10,000 of damages to the person that received them, you write a check for double the damages, for $20,000. So whatever the damages are, you are reimbursing them double, and that is the law's punishment to you for failing to maintain your fence. The law goes on to state after 2 breaches, if you still haven't learned, and this is a relatively recent update in the law, and there's now some case law that tends to support this. Previous breaches, if you haven't paid attention and you've had 2, after that, the plaintiffs can take their double damages and enforce a lien against the property, meaning that they can slap a lien on it the same as the mortgage that you have or possibly have on your farm. Does that make sense to everybody? I rent farms to run cattle on. So do you think my landlord is going to keep renting to me if I've had a couple of escapes and my cattle got out on the road and now my landlord has a mortgage type lien on the property? Likely not. So if you are running livestock, not only as the livestock owner are you responsible ultimately, the landowner themselves are responsible, and oftentimes those are 2 different persons, that the landowner might not be the cattle owner in that situation. So if any of you in here are landlords and are renting to somebody, you need to go check the fence every once in a while and have a good conversation with your renter. Yes, sir?
The lien would be for the value of the property or the value of the damage?
The value of the damages. And I'm using $10,000 as an example. I don't know that $10,000 is going to buy much in terms of vehicular damage. at that point. It could be on orders of magnitude greater than that. So everybody knows now, right, through double damages and possibility of liens on property, that building fence is extremely important. Now let's flip a page back to 042. You are now aware that you need to build some fence. Your neighbor may not be, or your neighbor might not agree with the fence law. That is one that I've heard quite a bit. That's a hard conversation to have. We're not talking about Santa Claus. We're talking about something that is documentable that you can go show them. I think what they mean is, I either can't participate or I won't. A lot of land owners that are adjacent to one another may be retired persons with fixed incomes, and you want to go in and build some fence. That fence that you're gonna buy, construct, or whatever, what are you gonna do with that expense? You're gonna throw it on your Schedule F, right? And you're gonna take it off of your taxes one day. Unless your neighbor actively has livestock, and the best that I can tell my 360 neighbors on one place, none of them appear to have livestock, they're not going to be able to take advantage of the same tax treatment that you are, or they could be on a fixed income and simply have the inability to pay for that. It's an unplanned expense that they simply cannot participate in. So those are two things that you might want to take a feel of as you go to speak to your neighbor. I always suggest a non-combative approach to talking with a neighbor, because even if you go through this and even if you get some fence built, who right now is calling you when your cattle are out? Your neighbor. Do you think they're ever going to call you again after you've sued them? Probably not. So we want to maintain that relationship with people that are going to be next door. Some of the people next door, particularly if they're landowners, may be passing that farm on to their relatives or heirs who will hold generations-long grudges. I mean, we are Kentuckians. We are very famous for huge grudges and feuds. And believe me, you can have family members themselves engaged in huge feuds over the fence law. If you,
Question about that?
yes, ma'am.
Okay, so we are in the process of getting ready to fence some pasture, or what was corn land into pasture, and we're having a dispute with our neighbor over the survey. But we were told by an attorney that if they actively grow hay and sell it, even if they don't have livestock, that they are responsible for sharing the cost of that fence.
Well, the attorney's not wrong, but anyone is responsible for that half of the fence. And I'll show you in just a moment where that is. This thing simply talks about when it comes to who can file, only one of the two parties need to be engaged in agriculture. So the landowner that's adjacent to you doesn't have to have hay or corn or soybean sales or anything. Their responsibility simply stems from being a landowner next door. So they don't have to be actively participating in agriculture.
So, Clint, say there was two neighbors, neither one in agriculture, one wants to put up a boundary fence.
That's a great situation. Now neither one of us are engaged in agriculture, and I've bought my 5-acre Scott County estate. And Chris has moved in next door and he bought his 5-acre Scott County estate. And he just wants a fence for aesthetics.
Or I don't like you.
Or he doesn't like me. Or Chris wants to run around with no pants on, doing something, and maybe I don't want to see it. You cannot use 042 as an enforcement tool on that. One side or the other can elect to put the fence up, but one of the two parties need to be engaged in agriculture. And I'll show you where that is. If we've exhausted the talks with the neighbor, you've met them at the fence line, walk the fence line with them. Sometimes that's therapeutic to see the conditions of things. Maybe they're able to get out, maybe they're not. Bring them coffee, pie. If that doesn't work, have a bourbon with them. If that doesn't work, have about 4 more. Then you all will be agreeing to all kinds of things. That fence included, Chris, but between us. if that doesn't work, and in your heart of hearts you know that there is no other way but litigation to move forward, 042, the balance of it is the roadmap for how to go about enforcing and finalizing the dispute. Number one, it tells you where to file. This is a district court action. Courts in Kentucky are divided into district courts and circuit courts. It's a difference sometimes of original jurisdiction about what court gets what. One court's misdemeanors, the other one's felonies, if we were talking about the criminal world. But when it comes to civil matters, the circuit courts get jurisdiction over matters that are generally $7,500 or better. Here, this says regardless of the cost, the amount of the fence, the exclusive jurisdiction is with a district court. Then it says down in number 2, and this is your question or Chris's question as well, who may sue? So here it just says the owner of a parcel of real estate used for ag purposes. So it only needs to be one of the two of you. Now think about who's suing here. It says the owner of the parcel of real estate. And remember, you're going to be suing your neighbor. So if you're a renter on a piece of property, can you go sue anybody? No. I think a lot of you that if you are renting ground to run livestock on, you may be shocked to find out that regardless of how poor the condition of the fence is, the landowner may be unwilling totally to go sue the neighbor, a lot of times because they're related. They might have totally different last names, but a lot of counties, a lot of people have married, intermarried, and there's a lot of history sometimes with adjacent landowners, and they simply may not wish to do that. In Scott County right now, and if none of you are running cattle here, I can tell you that the number one driver behind the inability to run livestock is the cost of the fence to maintain. And you have a lot of landowners that are unwilling to spend a lot of money on fence, particularly when, if the ground is suitable for it at all, it's cheaper to hay it out, to rent it to somebody to do hay, or rent it to somebody like me that'll put corn and soybeans on there. And then you don't have the cost of the fence and the liability that comes through that. Yes, sir, you had a question?
Doesn't the landowner get hung for any liabilities in their
Yes, sir, you're absolutely right. So that's in 030 here, and then in 080, the double damages. So remember, if you're the landowner and you're renting out, you need to have some confidence in the fence that you possess, or confidence in the man or woman that you're renting it to, that they're diligently maintaining and have constant surveillance over the fence. So in number 2, it just talks about one of the two of you need to be involved in agriculture. It doesn't require both persons. And this is to require the initial or replacement of a boundary line fence. So when people call me, again, they're not calling me because they're getting along with a neighbor. I would love that call. I would just, if you ever get along with a neighbor, give me a call. Let me know what that's like. This says a boundary line fence, which begs the question of, do you know where your boundaries of your farm are? And how many people can say that? Because this is tricky. You can, because you have a plat. And you just said your neighbor is disputing the plat.
After 3 surveyors agreed that it's all the same, he still disagreed.
Yep. Did everybody understand that? And for the folks in Princeton, she said that they've had 3 different surveyors and the guy still disagrees. And that is Kentucky ag in a nutshell. It doesn't matter how many surveyors. He can hire his own surveyor and then still disagree with it. So that is typically lawsuit number 2 that's going to be wrapped around the fence law. Is you're going to sue over fence, and they're going to counterclaim saying the fence isn't in the right spot to begin with. And the thing is, they may be right. A plat is not 100% guaranteed evidence of ownership. It is everybody's best guess about what ownership is on that. In Kentucky, we have adverse possession, meaning that if the fence has been placed in the wrong spot, uncorrected, unmolested, and uncontested for a period of 15 years without permission, that wherever the fence is the new boundary. Now, your plat won't agree with it, your deed won't agree with it, but legally that parcel can be passed through a quieting of title action to the neighbor. So knowing where your fence lines are is crazy. So this farm that you're all going on this afternoon, the last new deed for this farm was created in 1880, which is the last time that's when this family bought this farm. This thing talks about going to the middle of the creek and walking up a hill. I think I know which creek they're talking about. I have no idea where the hills are. It talks about flat rocks on the deed. Now, they've had subsequent surveys that talk about meet points and boundaries, but you can see on this place where we're going this afternoon, if you would like to go back there, you can. It has 3 miles of Elkhorn Creek. The Elkhorn Creek is not flowing the same as it did when I was in high school and we had a flood, let alone the last couple hundred years. So sometimes if you're using geology as a fixed point, the geology might have changed over time. The tree that you're referencing might have changed, or they simply can't find surveying pins, stakes, whatever they may be, if they existed in the first place. Yes, sir?
Summarize that again. So you said
At
survey is not necessarily evidence.
Yes, a survey or your own deed is not perfect evidence of ownership. It is typically the best indication of ownership because your deed could be in conflict with your neighbor's deed. And I've seen these things all the time. It is very typical for somebody to sell a farm and say, oh, that thing's 100 acres, right? Well, how do you know? Grandpa told me. Was Grandpa a surveyor? When you go to actually sell the property, it ends up being 85 acres. And there could have been a division with a neighbor or a cousin years ago where they both had the same thing in mind when it was divided, but legally it was drawn totally different. So you have to know where your boundary line is because your neighbor will fight you on that after you've given them the lawsuit. Yes, sir.
So in the comparisons of the two deeds, does it fall upon the oldest dated deed line if there's no adaptation made to parcels of land being sold off? If it is a comparison of old age riding of elm tree on the hill 16 paces northward to the north fork of the river, doesn't matter whoever has the oldest deed, is that what it's based upon and they have right?
Okay, for the benefit of the folks in Princeton, he's saying if there's a battle of the deeds, who wins? The oldest deed? And the answer is typically no one will win in that situation. A court will have to determine where the boundaries are. It's not simply because you have the oldest deed. One of the neatest parts of Kentucky history was Henry Clay, who has the nice house in Lexington and the great orator, and everybody learns that in their history books. Henry Clay became a famous attorney fixing deeds for people that were written in the American Revolutionary War when a lot of the land grants were written for these counties. Some of them are just horrible. I know that a lot of people think that plats and county plats, and particularly Scott County's PVA has a great website, and if you imagine it as a lot of puzzle pieces, all the puzzle pieces ought to match, right? Well, what happens is the puzzle pieces may match, meaning land will match, there's no gaps, but the deeds, what they're describing can be radically different shapes on those pieces of paper. So the answer is whoever's got the best deed typically wins, and that's probably what most accurately describes the land itself, how it's used, and then how it's historically been treated. So that's pretty hard. Yes, sir.
So you said if I build a fence on my neighbor's property and it goes uncontested for 15, 20 years, it could become the boundary line. But
Yes.
what if I intentionally put my boundary fence on 5 feet inside my boundary line?
And give them permission to use that other side?
Yeah.
Okay, for the benefit of the folks in Princeton, because I get this all the time. Well, I know I need to build a fence. I'm going to tuck it in on me 5 feet, right? And that way it's all my fence. That other fella can't even touch my fence. Will that affect adverse possession? Maybe. You need to give the other side some permission to do that. But what if I'm the other side and I read the next line down in the fence law and I say, that's great, you've got a fence 5 feet into you. Now I want to go build boundary line fence with you. So the fence you constructed doesn't meet your legal obligation of having a boundary line fence.
So is the fence the only marker? Because we've got trees on the property line.
If the trees match the deed.
Yeah.
So that's what Chris has probably listened to several dozen of these so far. The question always becomes whose deed's better, and I can never tell on that. And the best evidence is whatever you can lay it out to be, and typically that's best deed, historical use, and people that will say, well, that side was always his, this side was this. Buyer beware when it comes to owning property or purchasing it.
What you're saying is that if he built that fence 5 feet in, that becomes the new boundary?
No, I'm saying that if you build fence and tuck it in 5 feet, that's great, because you and I, as neighbors, are gonna go build some fence on the boundary where it's supposed to be according to the law. So it just means you get to build fence twice. And you're going to school for it. That might help sell some of the staple guns. Staples, not steeples.
Build a fence 5 feet in, and then I maintain that 5 feet for 15 years.
If you do it without permission, then adverse possession has taken place. But if you've maintained it with permission, then the clock never starts on the 15 years. Don't steal property from your neighbors. I feel like I really ought to throw that out right now, just to cover me. Nobody's stealing any property. I can say that I have done this twice now. Okay, look, he's asking, is it verbal or written? As an attorney, I'm going to tell you, if it's not in writing, it never happened. Because if we're going to come down to whose memory is the best, I'm going to remember all kinds of things that you forgot. Yeah, I've got a lot of contracts you've signed too, Dr. Jackson, that you've forgotten about.
That's basically where I was at, was because for example, I built a fence 30 feet off the line because I own all the way to the other side of the creek, but it runs like this.
Yes,
I don't
and
want to put in a bunch of water gaps, so I just kept, because it's not a flowing creek, so it doesn't give me any benefit for cattle.
yes,
But
so
he knows, or my property pins are still on the other
let's
side.
come back to water in just a second. Let me get through these, and we're going to come back to if your fence is on to the middle of the road or if the fence is to the middle of a creek, because my boundary where we're going this afternoon is to the middle of the creek. 7 minutes, we've got time. I'm optimistic. So you come down into 3. This describes what's called the initial complaint. And a complaint in a lawsuit is where you air your grievances, if you're a Seinfeld fan. You go in and you lay out all the grievances you have against your neighbor. And for this one, it just tells you kind of a couple different things. One, you got to describe the property boundary. And then number 2, you've got to say the fence is no good. That's about it. How do you document that the fence is no good? The cattle escaped at least once, and you've documented it sufficient enough to meet judicial review. Meaning that you've gotten out there, you've taken pictures, you've drawn maps, you've used Google Earth. You can say, not only did the cattle get out, but they got out on my neighbor's side to maintain. Because you're not going to go into court and sue yourself for an escape that happened on your own side to maintain. Yes, sir.
090 liability when my break whatever it says they are not responsible for the first trespass.
Yeah, that's if you have a lawful fence, meaning that if your cattle if your fence kept the cattle in, there wouldn't be an escape. By their merely escaping means that it wasn't a lawful fence. We got to remember, guys, particularly on this day, if nothing else, we don't elect politicians based on how smart they are. I mean, you all can giggle about that one all you want. All right, so the General Assembly, that is an apparent conflict there, and it was a conflict with the definition of a lawful fence on the front side. So if the lawful fence is keeping the cattle in, you can't have both at the same time. You can't have an escape and a lawful fence.
About a catastrophic event like a storm comes through, a tree falls on a lawful fence.
And when you all drive out there, I want you to notice this, because in the probably 100 talks, God, that's probably light, a couple hundred interactions that I've had with groups like this, I get asked, what is the standard type of fence and what do you do? And my response every single time is perimeter fence, boundary line fence means woven wire. That's not because I'm anti-electric. I love electric. It's cheap to build compared to everything else. And they ask why, and I say because woven wire fence or plank, if that's what you decide to use, doesn't require active power forever, and it's better for storms and mishaps and things like that. The problem with some of that is fence placement in areas that are knowable and foreseeable to have accidents. So when you're all driving out there today, you will look, as we kind of get on the top of the hill, please look. I mean you all to do that. We move equipment up and down that road, and I rarely see people looking at the road. They're mostly looking at their phones, and I don't want to get hit. But as you look at Bob Halls on the right, start looking at the high tensile fence on the left, and we have maintained that high tensile fence along the road specifically for ease of repair. So 2 weeks ago when we had the rains in Scott County, we had 3 accidents. 3 people ran off the road in the same spot in 24 hours. So if I know that that's a problem spot, should I be running cattle in a spot where I know that the cars are going to come off the road after a rain? Is that foreseeable to me? If I'm the attorney and I'm suing you, is that what you want to hear? As I'll say, hey, Mr. Quarles, how many times have you had a breach of the fence line in that area? Or that sketchy tree, did you know that tree was dead? Yeah. Is it a sycamore tree that sheds things recreationally from time to time and destroys the fence? Yes, I was aware of that. So it starts eroding some of the response that I could have as a defense in the lawsuit. Number 4, so we get past that. Number 4 is actually a command of the judge, and that's relatively rare in Kentucky law, that a judge is not allowed judicial review and appropriate judicial relief. In number 4, it says, if bad fence, then you must build fence. So if a judge determines you have bad fence, or even better, you can show that no fence exists at all, which again is very common when you have gone to an auction or bought something in a larger farm that got broken up. There may not be an interior fence because the farm, as it existed just prior to the subdivision, was configured in a different manner. There may not be any fence. That one says, if bad fence or no fence, the judge must order a new fence built. Down in 4A, B, C, and D tell you a few different types of things. Number 1, it tells you the type of fence that a judge can order built. Typically in Kentucky, a judge is ordering woven wire fence between neighbors built. There are some exceptions to that. Terrain is one of them where they can order strands of barbed wire or something like that. I've not seen a case where a judge has ordered electric fence as a boundary line fence to be built. I have seen a couple cases where if the lawsuit was going to go forward, they have ordered plank, and that was simply because of how the 2 existing horse farms kind of got to that point, that plank was replacing plank. Otherwise, typically judges order woven wire, typically with a strand on top. B is great. This B says the judge can order vegetation and other stuff removed, and who gets the junk when you're done. Most fence lines grow up over time. My family farms in Franklin County, where my ancestors are from, it's like going back in a time machine. The Quarleses would build a fence, not maintain the fence, and think, next time I'm going to. And I'm going to move the fence 5 feet down the hill. And I'm going to maintain that. And then they don't. And now the fences have migrated sometimes several yards away from their initial placement point because generationally we don't like mowing or weed eating. For this, if trees have grown up, the judge can order that path cleared, which makes new construction of the fence easier, and it makes finding that boundary line, if you're shooting it with a laser, it works a lot better when there's no tree in the way. So the judge can order that. C, The judge can order the stumps, rocks, dirt, debris, clay, whatever it is that was left over, who gets those piles. D is important. So if you sue your neighbor, really pay attention to D here. D says the judge can apportion cost, which is radically different than how the fence law reads in just another paragraph down. Apportionment of cost means if we're suing over that 1,000 foot of fence, the judge can order that to be divided 50-50. Meaning, if you're contemplating a lawsuit with that neighbor and your side's really expensive to build and theirs is not, and you have to go through the efforts of suing them, the judge can go halves on that cost. So just be aware, sometimes it's cheaper to build your half of the fence first and then sue for the other side. 7 talks about, as we've already been over 6, 7 talks about if you don't pay for the fence or you don't agree to it, number one, if you ever lose or win the lawsuit, go take bids to have the fence built. Because they're going to be so mad at you that it does not matter what you do, you're going to be wrong from that point forward. So you call a contractor that builds fence and then have them build the fence. Take bids, go have that done. If they elect not to participate in that, you can go back into court and get a court order to build the fence. If they don't pay that bill, you can get a statutory lien on the piece of property, and you can get statutory interest on that piece of property. I have 2 more things because I'm not even looking at Chris because I know I'm over time. We had one question about if the boundary is, or what is a boundary when there's not a natural boundary. So county roads in Kentucky, your deed typically goes to the middle of a county road. So it's important to know if the neighbor in the front, so to speak, is the state, if it's a state-owned road, or if it's the county. If it's the county, your deed goes to the middle of the road. Of course, you're not going to be putting fence there. So it is the gentleman's agreement in Kentucky that you fence your own farm in the front, which is always the side of the road. If you do have a deed, like mine where we're going, that goes to the middle of the creek, it's also impossible to build fence there, but you talk to your neighbor in that situation. In almost every circumstance, it makes more sense to do what you've done and you fence back away from the creek, and then the neighbor on the backside fences away from theirs, or elects not to build fence.
That's where I was getting. So I own all the way through the creek.
Oh, okay.
But rather than making 4 water gaps, because what I was gonna do, because the creek does this, then I just moved everything to my side. He doesn't take ownership of that. It ends up a couple acres over 2,000 feet.
As long as you all have an agreement to that effect and you've documented that somehow, then that's what I would do. Yes, sir. Try to find that happy median. But sinking posts in the middle of a creek is not going to be a long-term solution to anything. It'll be a solution until the next time you get water, down in the creek. Water gaps are incredibly expensive to build and maintain. If you can eliminate those things, do it. If not, a lot of other deeds and the way that the property lines are divided, it's just not an option. But any creative solution that you have, just discuss it with the neighbor. Try to avoid a lawsuit to the extent possible. Yes, sir.
What about title companies as far as their responsibility when you purchase the property for these existing boundaries?
A title company ensures that the title you're getting is good, not what necessarily is represented on the title, meaning that your predecessors in title all sign the deed. That if 4 siblings owned a property together, that 20 years ago one of them forgot to sign the deed or something like that. They guarantee that the title itself is good. The representation of what the corpus or the body of the title is not typically what a title insurance company is representing, because it would be impossible for a title insurance company to be aware of contingent interests like adverse possession, that they may not be aware of what's going on, or other encroachment issues, be it through easements with power lines, water lines, sewage, things like that. That's typically an exclusion in your title policy. So I would read that. That's an exclusion on virtually, I think, everyone that I've ever read. But that's a great question. Guys, I'm standing in between you guys and lunch, which is always a terrible place to be strategically. I'll be available this afternoon, or I'm sticking around for lunch. I'd be happy to talk to you and answer any questions you all have. For the folks in Princeton, I'm sorry I couldn't be here for that. Thank you all again.